This is really about getting justice for one party and punishing the other party. It is becoming a public spectacle. Hi, everybody. It's me, AV. Welcome back to my channel where we talk about all things law, true crime, and a little bit of debauchery. The tea is still piping hot when it comes to Tony Buzbee and Jay Z. Let's get into it. We have to start with where we left off. We know that Jay Z's team gave a deadline to have the judge grant an emergency motion, a response from the Buzbee team to drop this lawsuit involving the then 13-year-old woman that made accusations against Jay Z. Now, emergency motion, we have not heard from the judge yet, but what we do have is something from the Buzbee team, a letter to the judge that was released this morning. In addition to the letter that Buzbee's team released this morning, we also have a crazy thing that happened. We have a lawsuit that was filed by a woman alleging that Buzbee gave her an STD, and it was filed yesterday. I mean, this case is starting to get a little bit outrageous and legally crazy. Let's jump into it. This is from the Buzbee law firm, dated today, December 20th. Dear Judge Torres, by letter motion filed on December 13th, 2024, defendant Sean Carter notified the court of his intention to file a motion to strike and a motion for sanctions immediately under Rules 11C2 and 12F. As with the defendant Carter's prior letters filed in this case, it is historic in tone, substantively groundless. Defendant Carter threatens plaintiff with a Rule 11 motion based on questions raised by one single television interview concerning events occurring 24 years ago, when plaintiff was 13 years old. Defendant Carter also asked this court to alter the federal rules of civil procedure in his favor by abrogating the mandatory 21-day Rule 11 safe harbor period without a legal support of factual justification whatsoever. The former is frivolous and the latter is impermissible. So real quick explaining that, the last time we were here, guys, I explained to you what Rule 11 is from the Federal Rules of Civil Procedure. It is Law School 101 in civil procedure. Rule 11 means that as an attorney, anything that you put in a legal document must be as factual as possible for you as a lawyer to sign your name on the very last page. We cannot lie to the court. There needs to be candor to the tribunal. Now, what happens, and the reason why Rule 11 was brought up, the reason why Sean Carter's team is calling this a violation of Rule 11 is because there were inconsistencies in what was filed in the initial lawsuit versus what was said on this NBC interview. And here, Buzbee is correct that there is a safe harbor period of 21 days to review the allegations of a Rule 11 violation. Defendant Carter's threat of a Rule 11 motion is frivolous because it characterizes run-of-the-mill disputes of facts as proof that plaintiff's complaint is baseless. None of the factual issues Carter identifies are sufficient even to grant summary judgment in Carter's favor, much less support Rule 11 sanctions. The fact that the defendant or a potential witness does not agree or recollect the facts alleged in the complaint does not and cannot give rise to a motion for sanctions for filing a baseless complaint. Defendant Carter's threat of an immediate sanction motion on the first whisper of factual uncertainty is just one more instance of bullying intended to have a chilling effect on the plaintiff's counsel, and any potential plaintiffs watching these proceedings. A Rule 11 motion is frivolous on the additional ground that expecting a victim of sexual assault over decades ago, when the victim was a minor, and as her interview revealed, autistic, to have perfect recall of the fact is outrageous. Defendant Carter's twist plaintiff's words when he accuses her, for instance, of guessing what the timeline events alleging in the complaint, such as the length of car rides. But New York courts have expressly acknowledged that plaintiffs in this type of case cannot be expected to have an exacting recall and command of all the relevant facts. There is no basis for a Rule 11 motion here. And if filed, such a motion would in itself subject a Rule 11 motion in response. Of course, we cannot prevent defendant Carter from wasting the resources of this court and all parties in pursuing one. However, defendant Carter's request that the court shorten the filing deadline for his threatened Rule 11 motion from 21 days to 1 day is entirely improper. Carter fails to cite any precedent whatsoever to support this astonishing request, because there is none. Carter fails to cite any reason why the federal rules of civil procedure should be abrogated in his favor in this particular case. Again, there is none. The 21-day safe harbor rule under Rule 11 exists to provide parties and counsel time to assess the objections being made to withdraw or modify a pleading or other paper if necessary. The safe harbor period has been recognized by the Second Circuit as a strict professional requirement. From the outset, Defendant Carter and his counsel have shrilly maintained an entitlement to different rules and faster procedures, from expedited briefing on the issue of anonymity and a summary dismissal of plaintiff's complaint to now a wholesale elimination of the 21-day safe harbor rule under Rule 11. In such instance, the goal has been to blur the facts and rush a decision. But there is an aggressive advocacy, and then there is bad faith. Mr. Carter's latest tactics, much like his open threat to refer plaintiffs' attorneys for disciplinary actions, cross that line. Moreover, outside of the courtroom, Mr. Carter has employed tactics of intimidation and harassment, even more extreme, tortious, and quite possibly illegal. My firm recently filed a lawsuit in Harris County, Texas, that details how Mr. Carter's company, Roc Nation, and his counsel have bribed my clients to file lawsuits against my firm, threatened former clients, impersonated state officials, and engaged in other behavior far beyond the pale of acceptable conduct. Their tactics won't work, and they will be addressed in more detail in connection with the parties' briefing on plaintiff's anonymity. Like Mr. Combs, Mr. Carter is rich, famous, and powerful. Mr. Carter will exert all the pressure he can to intimidate and harass plaintiff, me, and anyone else. The chilling effect of those efforts is substantial, as is the potential chilling effect of a Rule 11 motion being bought in these circumstances. But ultimately, in our court system, the rules are the same for Mr. Carter and for the plaintiff here. And the Rule 11 safe harbor cannot be abrogated on his whim. Finally, Defendant Carter raises the status of my admission in the Southern District of New York, as with his previous letters to this court. His December 13th letter includes a substantial amount of defamatory suggestions about me, including that I am somehow attempting to circumvent the authority of this court to enforce Rule 11 against me. That is nonsense. I am a member of the State Bar of New York and am admitted to the Eastern District of New York, intend to apply for reciprocal admission to the Southern District. The fact that I have signed pleadings and letters filed in this court does not reflect any attempt by me to evade responsibility for anything. To the contrary, I have signed these pleadings and papers because I am lead counsel in this and similar cases pending the district. Respectfully, Tony Buzbee. So there you have it, guys. You have this openly notorious legal war happening between the Buzbee law firm and Roc Nation. It's getting ugly because now Buzbee is not backing down. However, he did have a responsibility to check a few things out. This is really about getting justice for one party and punishing the other party. It is becoming a public spectacle. But yesterday, Buzbee had a plaintiff sue him for contracting an STD. Let's take a look. Oh my God. Jane Doe by her attorneys, as and for her complaint herein against Tony Buzbee, alleges the following. Jane Doe brings this complaint seeking compensation for the harm she has suffered at the hands of defendant Tony Buzbee for his repeated failure to put his ethical obligations as an attorney over his self-interest. Defendant's deceit and lack of care left plaintiff with an incurable disease and caused her to lose out on assets she would have retained through her divorce. Since 2018, defendant has taken advantage of plaintiff for his own personal gain, but that ends now. The first time the parties met, defendant lured her into having a sexual encounter with him by concealing the fact that he had a venereal disease. Defendant knew of the risk that he would pass the disease to plaintiff if he did not take the appropriate precautions. And when the risk materialized, he manipulated her to protect himself from reputational harm using his status as a licensed attorney. Defendant convinced plaintiff to waive her right to monetary compensation contracting a venereal disease from defendant in exchange for free legal services, and then became possessive of plaintiff in order to keep her close and prevent her from exposing him from what he did to her. On one occasion, defendant became physically violent when he observed plaintiff speaking to another man at a bar in New York, leaving her with 2 broken teeth. Plaintiff became fearful of what defendant would do if she ever spoke out against defendant. In 2021, the result of the defendant's manipulation, plaintiff allowed defendant, who had just married a woman 23 years younger than him, to represent her in her divorce. Defendant assured plaintiff that he would fight for her to receive her fair share of material assets, but rather than uphold his promises and ethical obligations to zealously advocate for plaintiff's interests within the confines of the law, defendant used the opportunity to doctor plaintiff's medical records to make it look as if he could not have been the one who infected her with the venereal disease. Defendant then used his blatantly falsified records to attempt to blackmail the plaintiff's husband to circumvent ordinary negotiations to distribute assets in the context of the divorce. When that failed, defendant arranged a settlement that left plaintiff with a fraction of what she should have received in order to resolve the matter as quickly as possible and bury his egregious conduct. Defendant recklessly gave the plaintiff a venereal disease and manipulated her into silence. In early 2018, plaintiff connected with the defendant online, where he charmed her with conversation and persuaded her to meet in person for a date. Plaintiff traveled to the defendant's hometown of Houston, Texas, where he took her to dinner and a show. After the show, defendant invited plaintiff to stay and have a few drinks, and then arranged for them to spend the night in a 5-star hotel. Defendant seduced plaintiff into engaging in sexual activities without disclosing that he had a venereal disease. After spending the night with the defendant in early 2018, plaintiff began to feel uncomfortable sensations around her groin. Plaintiff made an appointment with her physician to address the issue. Shortly after the appointment, plaintiff's physician informed plaintiff that she had contracted a venereal disease from her encounter with the defendant. Plaintiff's physician shared her unfortunate news that the venereal disease was an incurable disease that could cause her pain and embarrassment for the rest of her life. After receiving the venereal disease diagnosis, plaintiff called the defendant to inform him that he had transmitted a disease to her. Defendant was apologetic and unsurprised because upon information and belief, he was already aware that he had a venereal disease and that he did not take appropriate precautions to prevent transmission when they were engaging in sexual activities. Defendant instructed plaintiff not to tell anyone and offered to provide free legal services as compensation for his deceit and carelessness that resulted in plaintiff contracting an incurable disease. Filled with the shame and grief over her diagnosis, plaintiff continued seeing defendant, the only sexual partner she would not have to inform of her venereal disease test result. Defendant became possessive of the plaintiff in order to keep her close and manipulate her into keeping his secret. Defendant began inviting plaintiff on trips with him on his private jet to Panama and New York City. While in New York City with defendant, plaintiff and a friend had a drink at a bar where defendant would later meet them. When the defendant entered, he observed plaintiff conversing with another patron at the bar. In a jealous rage, defendant smashed plaintiff's glass into her face, causing plaintiff's front teeth to chip. Plaintiff became fearful of what defendant would do if she ever spoke out against the defendant and stayed silent until filing this lawsuit. Defendant committed legal malpractice and violated his ethical duties to cover up his misdeeds. Approximately 2.5 years later, in 2021, plaintiff and her then husband initiated a divorce. Consistent with his promise to provide free legal services in exchange for plaintiff's silence, defendant undertook representation of plaintiff in her divorce. Defendant assured plaintiff that he would fight for her to receive her fair share of the marital assets. Defendant used his position as the plaintiff's sole attorney as an opportunity to doctor plaintiff's medical records to make it look as if he could not have been the one who infected her with the venereal disease. Specifically, defendant falsified the test to show that she contracted the venereal disease in 2020 from her soon-to-be ex-husband rather than in 2018 from the defendant. On April 13, 2021, defendant sent a demand letter to plaintiff's husband with a knowingly fraudulent claim that he, rather than the defendant, had infected the plaintiff with a venereal disease. Defendant's attempt to blackmail did not work, and plaintiff's husband continued to litigate the divorce. On June 14, 2021, prior to mediation in the divorce proceeding, plaintiff's husband made requests for discovery related to defendant. Defendant insisted that the divorce settle quickly and without discovery. Upon information and belief, defendant provided this advice to avoid production of the documents that would cover his fraud and his role in infecting plaintiff with the venereal disease in 2018. At defendant's insistence and direction, plaintiff entered into a divorce agreement that resulted in a dramatic loss for plaintiff, who otherwise stood to recover an equitable split of marital assets. Defendant also directed that the divorce settlement include an arbitration clause, precluding plaintiff from further litigation with her husband. Defendant inserted this term to prevent his involvement with being exposed in courts open to the public. First cause of action is legal malpractice. Second cause of action is violation of judiciary law. Third cause of action is breach of fiduciary duty. Fourth cause of action, fraudulent misrepresentation. Fifth cause of action, tortious interference. Sixth cause of action, declaratory judgment. Prayer for relief. What does Jane Doe want? She wants actual damages, consequential damages, punitive damages, and any such other relief available under the causes of action in the amount to be determined at trial. A declaration that the divorce settlement is null and void, or in the alternative, that the defendant's malpractice deprived plaintiff of her right to a portion of the liquidity event. The cost of bringing the suit, including reasonable attorney fees and such other further, a different relief as to the court appears just and proper. So ladies and gentlemen, as you can see, this legal war between Jay Z and Buzbee is getting ugly. Obviously, this woman spoke out on it. It is an unrelated matter. However, it's just the timing of all of this happening at the exact same time. Let me know what you think in the comment section. Is this an attempt to smear Buzbee's name? Stay safe out there. See you in the next one. Bye.